January 1st, 2020, it looms large. It is an idea some people have that it is an apocalyptic shipping hell when everything is going to happen for which we're not prepared. May God be with us, said a very prominent representative of Greek shipping last June at the press conference. And somebody else who is very important in shipping recently said it's like a coming tsunami. We're talking about the 0.5% sulfur cap. On the other side, there are those who believe that the coming change is an environmental imperative. This is ships operating on batteries, hydrogen, and ammonia cells. Even some shipping NGOs support strict enforcement. The rush to implement the sulfur cap 5 years ahead of schedule and the coming IMO initial strategy goals of reducing greenhouse emissions by 50% by 2050 are cause for alarm. This is perhaps what happens if you let bureaucrats loose to write regulations without reference to business reality, market capacity, and engineering feasibility. But this is political talk, and I'll get out of it immediately because I'm a lawyer and I will talk about the law. American lawyers are asked about the new sulfur cap that is going to take effect in the first of the year. And their question is whether the United States is going to implement criminalization as a method of enforcement for non-compliance. Until fairly recently, last June the 20th, I would have guessed. But the United States Coast Guard and the Environmental Protection Agency came up with a protocol. And the protocol has a long title. It's the United States Coast Guard and United States Environmental Protection Agency Revised Protocol on referrals under MARPOL Annex VI as implemented by the Act to prevent pollution from ships. As it says in the title, and if you read through it, and I urge you to go and find it, you can find it on Google, at the core of the enforcement is going to be the Act to prevent pollution from ships. And this is a broad piece of legislation that provides for both civil and criminal enforcement. At the core of enforcement is the United States Coast Guard. It is taking point. They are the contact of the enforcement authorities with the industry. And they attend your ship either for port state control purposes or for other inspections such as a certificate of compliance. For sure, the Coast Guard, when ships start coming to the United States after January 1st, are going to check to see if they fulfill certain requirements of the sulfur cap. If you sail in an American port and your bunker tanks are full of non-compliant fuel, you should expect to be detained and the matter to be handled after that. But how is it going to be handled? And there are certain protocols of IMO that suggest it may entail even pumping out of the ship the non-compliant fuel or other means. The lowest of the sanctions that you should expect, according to this protocol, from the law enforcement authorities of the United States is a letter of warning. Letter of warning carries no sanction, but it goes in your record. And the next highest sanction is a notice of violation. And a notice of violation provides for a fine predetermined in amount, calculated on the basis of your record. If the offense is more serious, then the Act to Prevent Pollution from Ships provides for an administrative penalty and a hearing, and the cost is going to be $25,000 per violation. Each day that passes is a separate violation, and $5,000 for each false statement that you make to the authorities. If the violation is really serious, the enforcement agencies, Coast Guard and EPA, will refer you to the Department of Justice for a criminal prosecution that my friend Mr. Tadros talked about, and that carries a fine, a maximum fine of $500,000 per violation, and the violations usually are layered. They're multiple if they decide to do a prosecution. But this is a detention form, civil penalty, the criminal prosecution. Now, what do we know about what enforcement is going to be really like? Fortunately, Annex VI has been in effect with emission control areas, the North America emission control area and the US Caribbean emission control area since 2012, 7 years we have experience, and we have a general idea of what it is going to be like. There is experience on the part of operators and experience on the part of authorities as to what actions they have taken. One thing I can tell you for sure, and perhaps this will set your minds at ease a little bit, is that if you sail with non-compatible fuel and you do that outside an ECA, when you get to the United States, you cannot be prosecuted for that. And you cannot be prosecuted civilly, fined civilly and have a civil proceeding or a criminal proceeding. And the reason for that is because the writ of the United States does not run beyond 200 miles from its shores, beyond its ECAs. You can do all the violations you want in terms of what fuel you burn. On the other hand, once you enter the ECA, there are numerous things that the American authorities can do to criminally or civilly enforce the coming 0.5% cap. They look at your oil record book, and it has to be truthful, and they prosecute you for having committed an offense in the United States, that is, maintaining a fake oil record book while you're there. They can look at your receipts, your bunker delivery notes, and I'm running ahead of myself a little bit, bunker delivery notes, and these have to be accurate and truthful. They cannot be fakes. They can look at your samples, and these you have to maintain faithfully, and they have to be available for presentation in case they want to go further with enforcement. And of course, a good counsel learned from civil enforcement cases for administrative enforcement cases is if you don't have available the bunker you need when you go towards the United States, file a fuel non-availability report with the captain of the port where your ship is destined, and this way it has to be supportable. It cannot be something you just thought of and you could have sourced the fuel you need. This way, the consequences are not going to be harsh, or maybe there will be no consequences, a small fine perhaps. Now, going on to criminal enforcement, there has been one case in 7 years total for violations of Annex VI. And my friend, Mr. Tadros, I think, referred to it. And in this case, you should have expected that it would happen. There would be a criminal prosecution because everything on this ship was done by the How Not to Do It book. The entries in the oil record book were fake. The fuel tanks contained high sulfur oil, and they contained low sulfur oil. The bunker delivery notes were forgeries. They were fake. What do you expect? They brought down criminal sanctions, and the case was settled, and a guilty plea was entered. Bottom line, for purposes of Annex 6.5% sulfur cap, stick to the truth. Truthful entries in the oil record book. Bunker delivery notes proper and maintain them. Keep your samples. File fuel non-availability reports when you call in the United States. This way, can I revert? This way, you will avoid being proceeded against. Thank you very much.